Well, we know the outcome. The utility box was moved to a better site for Amy. So what was the ADR process like for her? Can we do a flashback like in the movies and show Amy's ADR process as it happened?
Barbara, we're in a movie. We can do anything we want.
All right. Flashback, 4 months ago, Amy's ADR adventure.
The Public Advisor's Office suggested that Amy contact the ADR coordinator to see if her case might be suited for the program.
Hi, this is Amy Smith. I'd like to speak to the ADR coordinator. Great, thank you.
The coordinator's contact information is on our website, and it's listed here. The ADR coordinator's phone number is 415-703-2194. Ideally, ADR requests are made early in a formal complaint proceeding. However, parties may request it at any time if they feel ADR will resolve their dispute. In addition, the Chief ALJ or any ALJ reviewing a case may recommend mediation for it. The ADR coordinator will send a notice, often an email, to both parties recommending they consider mediation. If they agree, a mediator will be assigned to the case.
That's great. Yes, the utility and I have agreed to try mediation. Okay. A mediator will contact me soon with details? Great. Thank you.
The mediator contacts the parties to discuss the mediation process, information about the first session, and the issue of confidentiality.
Yes, I've read through the mediation agreement and signed it. Okay. You want me to bring it? I'll bring it to the first hearing. Thank you.
Both parties are required to sign the confidentiality agreement before or at the first mediation session. Sessions are held at the CPUC headquarters in San Francisco, but other more convenient locations may be used if requested. The mediator may also require both sides to prepare for the sessions. As in informal and expedited complaints, each party may be asked to bring materials or evidence regarding the dispute and prepare a summary of the case. Additionally, the mediator may ask the parties to look over some preparation questions. The questions are aimed at encouraging both sides to begin thinking outside the box with regard to their needs, as well as the position of the other party. Each side may be asked to clarify the key points in their case and perhaps list any external factors in the dispute that are beyond their control, like the issue of the easement in Amy's case. The questions serve to open up the dialogue between parties and prompt ways to think about resolving the conflict. Some of the topics in the questions may be touched upon in the mediation session, which is why we ask parties to look them over. And it's fine to bring the questions and answers to the mediation, but it's not mandatory. A sample of the questions are listed on the website.
It needs to be moved.
At the mediation, the parties discuss their case in the presence of the mediator.
As we discussed with Ms. Smith, we're able to move the box to a less conspicuous location on her property. But there are engineering and construction costs involved. We would like to work with her on this matter, and we're willing to find the least costly way to effect the move.
How do you feel like this is going for you?
Well, I understand that I'm going to need to pay to move the box, but I need to be guaranteed that it's going to be put in a more acceptable location than this, and that the cost is going to be as low as possible.
The mediation process, whether it's successful or partially successful, is usually concluded within a half day to 2 days. At the conclusion, when mediation resolves the complaint with a complete or partial settlement, the complaint is often able to be withdrawn. If the parties don't settle, the case may proceed through the formal complaint process. If the parties reach an agreement, the case may simply be withdrawn. In other cases, the parties may agree, but commission approval may be needed. In that case, the ALJ assigned to the case will write a proposed decision for the commission to vote on.
Now structurally, this site could support the box, and we can move it in less time than was originally estimated, which will reduce your costs significantly. However, we are going to have to ask you to move the easement to this new location so we can have access to the box at all times.
That's great. It's going to cost less than I originally thought.
Of course, it is still a chunk of change, but...
It is. Settlements may require one or more of the parties to perform certain tasks to fully satisfy the agreement. And some agreements are a written contract that may be enforced by a court.
Okay, a happy ending. That's my kind of story. But mediation sessions really occur just within 1/2 to 2 days? That's all?
That's right. Mediation sessions take about a half day to 2 days. A typical mediation procedure, from requesting ADR to the conclusion of the sessions, takes about a month. We strive to keep the ADR process efficient.
Well, when isn't ADR used for formal complaints?
Good question. ADR isn't used in strictly legal cases, such as rate setting involving utility, or rulemaking involving policy decisions. But ADR can help resolve a lot of other types of formal complaints, or even portions of a complaint.
Well, in Amy's case, she won, and so did the utility.
That's what we like, win-win.
Well, thank you, Ken, for taking us through the ADR process.
You're very welcome.
And thanks to all of you residents and small business owners for your interest. To continue getting win-win results with your questions, go to the main menu and access specific chapters. I'm Barbara Rogers, looking forward to seeing you soon.
And I'm Tomas Roman, admiring the outcome of ADR. Join me in the next chapters as we continue to get our questions and complaints addressed. Here, let me move this.